I'm Drew Stevenson, and this is a lecture about the case Bostock versus Clayton County. This is a fairly recent decision from 2020 from the United States Supreme Court about the plain meaning of the statute versus looking at historic interpretations of the statute. And this is a case in my Statutory Interpretation and Regulation casebook. We're looking at it solely for the issue of how the court and the dissent are interpreting this statute here. We're not focusing on the civil rights issue or the constitutional question. So you may have studied this case in a constitutional law class or discrimination law class to look at the merits of the holding or how it changed the law. And for our class, we're just looking at how the court sort of unpacks and construes an older statutory provision and applies it to a modern context. So let's look at what happens in this case. So let's start with the facts. These are really three consolidated cases in which an employer had fired a longtime employee shortly after the employee revealed that he or she is homosexual or transgender. And allegedly, in each of these cases, for no other reason than the employee's homosexuality or transgender status. So there were no assertions that the employee had been a bad worker or misbehaved or missed work or things like that. And pictured here is Gerald Bostock, the person whose name is in the caption of the case. And our statute is Title VII, which is a federal law that says it's unlawful for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individuals' race, color, religion, sex, or national origin. So this is sort of the centerpiece of federal employment discrimination law or anti-discrimination law. And the operative word that we're concerned about for this case is that word sex and whether that applies to homosexuality or only to a person's biological gender. And the court here holds that Title VII forbids discrimination on the basis of sexual orientation, which is part of the statutory term sex. And the court relied on earlier cases where it interpreted this word broadly. And so we have that term sex, and you might think that that just originally in the 1960s when they enacted this act in 1964, that they were talking about men versus women in the workplace. But in the years in between, the court has applied this to include concepts such as motherhood or same-sex discrimination. And so, for example, to give an example, when women would be fired or given a pay cut when they got pregnant, employers at first tried to argue that they weren't discriminating on the basis of sex or gender. They were discriminating on the basis of being pregnant. And the court said that that's included in the concept of sex. And similarly, there were cases where, let's say, a female worker, a woman worker, was experiencing mistreatment or unfair treatment by a supervisor who was also a woman. And so the employer tried to claim, well, it can't be discrimination based on sex if the person doing the discrimination is the same sex as the purported victim. And the Supreme Court had held already, long before this case, that the sex provision in Title VII can still apply even when the alleged mistreatment is happening from a woman to another woman or a man to another man. And so the court, here's a quote I pulled out from the opinion for you. The court normally interprets a statute in accord with the ordinary public meaning of its terms at the time of its enactment. After all, only the words on the page constitute the law adopted by Congress and approved by the president. And I pulled this out because this is sort of the classic statement of textualism. It's like a four corners rule for statutes, that only the words on the page or what they voted on in Congress, both houses of Congress, and what was sent to the president for signature or veto. And so this is sort of a slam against using legislative history. But I also want you to notice that textualism has evolved a little bit over the years from an emphasis on what Congress must have been thinking or meant, what the author of the words, their subjective intentions or meaning were, to the public meaning. And so this is a subtle difference that's important to recognize. So if we're focused, if you think about communication as the transmission through words, whether spoken words or written words, of an idea, and you're trying later on to understand what exactly was meant by an ambiguous phrase or term, well, one way to focus on it, or one theory of communication, is to look at what the person who was the author of the words, or the speaker, or the writer was thinking. And so we look for other evidence. What did they say on other occasions? What did other people say that that person meant? And so forth. But there's an alternate view of communication theory, which is focused on the audience. And so, in other words, it only has meaning if the audience can understand it. And so this view of statutory interpretation focuses on what the word would have meant to sort of the citizenry or the American public at the time the statute was enacted. Never mind what Congress meant or what the person who wrote the bill was thinking. The question is, how would the voters, or the people that the law is going to affect, would they have thought that the words meant? And that's all embedded right there in that quote from Justice Gorsuch's majority opinion. So let's move on. I pulled out another quote for you. For an employer to discriminate against employees for being homosexual or transgender, the employer must intentionally discriminate against individual men and women, in part because of sex. And that has always been prohibited by Title VII's plain terms. And that should be the end of the analysis. And so here he's applying the statute to the facts and saying Title VII applies and prohibits nationally employers from discriminating against employees based on homosexual or transgender status. The sort of bold assertion from the majority opinion is that that was always prohibited by Title VII's plain meaning or plain terms. And this was the dispute in the case, is the issue that we're applying this for the first time. The Supreme Court is being asked for the first time to settle an area of law about whether people have protection against workplace discrimination under federal law, under Title VII, for this status. And it was not clear before this case. And now he's saying it's always been clear if you read the statute. And so he's sort of, whether you think that he's being a textualist or not, he's doubling down on claiming that he is. I have a few more quotes from the opinion that are sort of illuminating. The employers contend, this is Clayton County, that in 1964, that nobody would have, or very few people would have expected this statute to apply to discrimination against homosexual and transgender persons. In other words, the majority is conceding that society has become much more inclusive or accepting of this, that there's less of a social stigma and so forth for homosexuality and transgender status. But the legislative history, he's saying, has no bearing here. So he's saying that when the employers are saying that no one would have expected this to apply the way we're applying it today, he's saying, oh, it sounds like you're invoking legislative history, and we're not talking about that, because he's saying that the term isn't even ambiguous, that the term sex is not ambiguous. And so he says, now, it's possible that a statutory term that means one thing today in one context might have meant something else at the time of its adoption, or might mean something different in another context. And so he's conceding that it's possible that a term was included in 1964 that has sort of evolved in its meaning as society has changed, right? And so there are terms like this that if you watch an old black and white movie, they use the words that we don't, and phrases and so forth that are less common now, or there's been subtle changes in the sort of semantic implications or associations of certain words. So he concedes that. He concedes that language is fluid and evolves over time, and that some words can have a meaning change over the decades or centuries. But he then points out that the employers didn't really brief that, didn't put on evidence to support that type of idea. The employers didn't seek any historical sources to illustrate, he says, that the meaning of any of Title VII's language has changed since 1964, or that the statute's terms ordinarily carried some missed message. So he leaves open that in this case or in future cases, if you want to bring in historical linguists who can put on evidence that a word has shifted in meaning over the decades, go ahead and we'll listen to that. But they didn't do that in this case, and so we're not going to do it for them. He also counters their assertion that nobody would have thought that this applied in this way back in 1964 from the fact, sorry about that, the fact that even right after the law was passed, there were at least lawsuits brought by gay and transgender employees under Title VII. So at least the individual victims of the discrimination thought that the statute applied to them. And so at least some people foresaw this potential application. So even if those cases weren't endorsed by the US Supreme Court or upheld on appeal at the time, he says the fact that they were filed at all suggests that we can't really say that there was a shared public meaning or consensus in society that this wouldn't apply in the way we're doing it. Now let's talk about another few canons of construction that sort of get mentioned in this case, because we're about to transition into that in this chapter and in chapter 2 of our casebook. So in chapter 2, we're going to talk about a canon called expressio unius, which is an old Latin phrase that was really just sort of an interpretive, a shorthand for the interpretive idea that if a statute says something specific, like specifies an item of what it covers, remember Title VII has a list of unlawful bases of discrimination. And so the employers tried to argue something like that without really invoking that canon by name, to say, look, it said sex, race, and so forth, and they didn't say homosexuality or transgender, and so if they specified other things, then they must have meant the list to be exclusive and not include those other things. The court characterized this, instead of being expressio unius, as the canon of donut holes. And I actually think that Justice Gorsuch sort of made this phrase up, in which Congress's failure to speak directly to a specific case that falls within a more general statutory rule creates a tacit exception. And so, in other words, he's saying if someone argues that silence in the statute about some specific case means that that's an exception, and he says that if that's what you're arguing, that's a canon of donut holes. So basically, or what I would have said growing up, you're arguing from silence. He also talks about another canon that he calls the no elephants in mouse holes canon, which, as far as I can tell, is really just another way of talking about a clear statement rule, but it's a more entertaining phrase for it. And this recognizes that Congress does not alter the fundamental details of a regulatory scheme in vague terms or ancillary provisions. And he said, but that has no relevance here because we don't have a vague term. He's saying it's clear in the plain meaning. So this is where this case is in our casebook right after the case King v. Burwell, which is in part a sort of a major questions doctrine case or a clear statement. And King v. Burwell was decided on the idea that if Congress had meant something that's such a huge decision that it carries so many implications, that they should have said it. We shouldn't be left to guess at something ambiguous, based on ambiguousness or a tiny little statutory gap. And so just for my students, I think we have another name for what Justice Gorsuch is calling the no elephants in mouse holes canon, but it's a nice vivid image of why we require what we would normally call a clear statement rule or the major questions doctrine, that we don't want to bury we shouldn't infer some major thing that's going to be very disruptive to society or the legal system or the economy based on some tiny little ambiguity or linguistic sort of glitch in the statute. Now, we do have a scathing dissent from Justice Alito, and I pulled out a quote from this that basically captures the gist of everything he says. There's only one word for what the court has done today: legislation. The document the court releases is in the form of a judicial opinion interpreting a statute, but that is deceptive. So what is he doing? He's accusing them of judicial activism or legislating from the bench. He's saying that they've essentially amended the statute with their decision. On the other hand, keep in mind that if he had won over a couple more justices and had the vote so that he was writing the majority opinion, his interpretation would control the application of the statute. So he has a point, but the counterpoint is either side in this case was doing something that would have a huge effect on the meaning of the statute. In other words, there's a sense in which courts are always making law from the bench. That's our common law system. And so even when we have a statute, as the years go by and the courts have to interpret and construe the ambiguous words in that statute and decide how far whether to apply them broadly or narrowly, that's part of what our judges and our judicial system have always done. But he's saying this should have been left to Congress, right? That if Congress wanted to change the statute, that they could just amend the statute whenever they want. And that concludes our lecture about the Bostock case.